Good morning. Happy Wednesday. Hump day. Get your hump on. News Now Ohio, who I affectionately call News Now Ashtray, who appears to have been on a decades-long meth binge and acts like he's been on a meth binge, has filed a lawsuit. I have not covered it. I'm not very much interested in it. I'm not very much interested in News Now Ashtray as a person, as an auditor, or as a legal rights activist. But he has every right to do it. He's asked me for my opinion on his lawsuit. Now, he says that the cops did not understand Houston versus Hill, a Supreme Court case. Now, I'm not here to help him with his lawsuit. I've read his complaint. I have not seen any of the videos associated with it. He alleges that he has an hour-ish long video. His complaint reads terribly. He was doing nothing, just minding his own business, and suddenly, out of the blue, the cops attacked him and wrenched his arm up behind his back. And then he says that they don't understand Houston versus Hill. So that leads me to believe that he doesn't understand Houston versus Hill. These Supreme Court cases aren't decided in vacuums. And so they have to mesh together somewhat harmoniously in order for you to get an accurate picture of what's going on, of how these things fit together. The way that auditors understand Houston versus Hill is that you can swear at the cops as much as you want. The way they understand Cohen v. California is you can say anything you want because he wore a shirt that said, "Fuck the draft." Now you can say anything you want. They can't criminalize swear words. You can say anything you want to police. They can't criminalize you swearing at the police. I believe there's a line of dicta, which I love. It's great dicta, but it's still dicta. That says essentially that cops have to be able to accept criticism, even if that criticism is peppered with spicy language or something along those lines from Houston versus Hill. It's been a long time since I've read the holding. Forgive me if I'm somewhat off on it, but that's essentially what it says. But it's dicta. You have to harmonize Houston versus Hill with all the other Supreme Court holdings where fighting words are not protected speech. Fighting words are outside of the First Amendment. There is no First Amendment protection for fighting words. So how do you harmonize the two of those? Well, if you look at Houston versus Hill, there was a statute that the city of Houston put in place that said basically if you interrupt or disturb an officer while he's conducting an investigation, then that's a crime. And the problem that the Supreme Court pointed out is that it's going to catch protected speech in it, and it's going to leave the cop too much discretion as to what protected speech is and isn't. Again, you run into that whole void for vagueness sort of thing. So had the city of Houston versus Hill only had that statute apply to fighting words like they do in disorderly conduct statutes, where words that tend to incite an immediate breach of the peace, i.e. fighting words, then it most likely would have been okay, because disorderly conduct statutes, irrespective of who the fighting words are said to, are still enforceable. So you can get charged with disorderly conduct for saying fighting words to a cop because fighting words are not protected by the First Amendment. They're outside of the protection of the First Amendment. So when News Now Ashtray is saying the cop didn't understand Houston versus Hill, my natural understanding, without having seen any of the videos, is that he was swearing at the cop. Probably not very inventive swears, probably just your standard go fuck yourself, eat a dick, yada yada. But the question is going to come. I don't think he was arrested. I think he said he was not arrested. But the question is going to come. Did the officer have reasonable suspicion that crime was afoot? I don't know. I don't know the language. And a lot of that's going to come down to a question of the jury. Does the jury think these are fighting words if he's charged with disorderly conduct? Another question, another concern with these kinds of things that you have to consider is that in every circuit that has addressed the issue, you have a right to film public officials in the performance of their duties in public. And police are public officials. But it's always subject to reasonable time, place, and manner restrictions. So the next question you have to ask yourself, after you get past the was I using fighting words, the next question is, was the restriction that the cops were trying to place on me a reasonable time, place, or manner restriction? Now, I know that auditors, especially auditors of the ilk of News Now Ashtray, don't believe that any restrictions on their ability to film and heckle the police are reasonable. But I don't believe it's them or persons like them who are going to get to determine whether or not the restriction that the officer was imposing was a reasonable time, place, or manner restriction. Obviously, that will come from the judge. The judge will determine if it is a reasonable time, place, or manner restriction. So, to wrap this up, in the best and only advice, I mean, unless I get a flood of comments down below about people just dying to know about News Now Ashtray's lawsuit, which I doubt is going to happen because I doubt any of you really know who News Now Ashtray is. A very small handful of you are going to know who he is. Anyway, so my best advice to News Now Ashtray is, number one, get an attorney. I read your complaint. It was pretty crap. You're going to want an attorney. If you can't find an attorney who's willing to take it on a contingency basis, there's your sign. It's crap. If you can find an attorney to take it on a contingency basis, awesome. If you decide to pay an attorney hourly to pursue it for you, which I doubt you will, because that'll cut into the meth budget, here's some helpful, friendly advice. I learned very early on in my career as an attorney that every case has settlement value. So even if you have a case that you would lose if you go to trial on, you might still be able to settle it and get some money out of it. The key to settling it and get money out of it, if it's a loser case, is to, number one, know when to settle. The when is just as important as the how much. And number two, know how much to accept for the case. You got to make an offer to them that is somewhere within the range of acceptability, because they might not be willing to make an offer to you if the case is just pure nuisance value. So know when to settle. Listen to your attorney. Your attorney might be able to give you some helpful advice on when to settle and how much to settle for, especially if he's on contingency, because he is going to want to maximize his dollary dues, and him maximizing his dollary dues, if it's contingency, means you maximizing your dollary dues. And if he's giving you a settlement amount that he believes is reasonable, that they would accept, you might want to consider that even if you think it's too low. Now, that doesn't mean he's perfect, obviously. You might be able to push both him and the opposing side into more money, but you also might talk them out of any settlement agreement at all, so bear that in mind. And number two, from what I've seen of your complaint, you're most likely going to get hit with a 12b6, motion to dismiss, qualified immunity, all the good stuff wrapped up into one. You're going to need an attorney. You're going to need an attorney. I don't think you're going to get past it without an attorney. Get an attorney. So in summation, your case appears to suck, but I haven't seen all of the evidence. Your complaint does suck, but the evidence might be stronger than what your complaint suggests. So get an attorney. Get the best attorney that you can get. If you can't get an attorney to take it on contingency, just understand that your case sucks. Your case sucks either to prove liability or to prove damages. One of those two is lacking, or both. So bear that in mind. If you decide to proceed anyway, if you can't get an attorney to take it on contingency, try to settle. Try to recoup as much of your fees as you can, and good luck. Anyway, that's all I got for you today. Moral of the story: Houston versus Hill doesn't let the state, i.e. a government, criminalize speech that is just critical of the police. It does not allow you to say whatever the F you want to the police. Disorderly conduct statutes still apply. They still apply, even to the police. I've seen them apply to the police. They apply to the police. You can't use fighting words against the police. If they arrest you for it, fighting words are not protected speech. So you don't have a First Amendment defense there. They're not protected speech. I mean, if you convince the court that they aren't fighting words, then you do. But if you can't convince the court they're not fighting words, then you're done. Anytime you're out there filming the police, you got to remember that you are subject to reasonable time, place, and manner restrictions. If the police are attempting to give you a restriction, understand that a court might find it to be a reasonable time, place, or manner restriction. And number 4, all cases have settlement value. The trick is to know when to settle and for how much, even if your case is a loser. Number 5, finally, if an attorney won't take your case on contingency, it's probably not a good case. Thanks for watching. Have a great day.